Welcome back to The Price of Business. I'm your host, Kevin Price, talking to you about you and your business. Going to be chatting with our friend, Marc Krasney, a great friend of The Price of Business, has been now for years. He's with the Krasney Law Firm, and he brings us interesting topics and issues and things people should be keeping an eye out for when it comes to the legal side of their business. Marc, welcome to the show. How are you?
Thanks, Kevin. Doing well. How are you doing?
Doing great. Tell us a little bit about the Krasney Law Firm.
Yeah, sure. We started almost 8 years ago really working as in-house counsel for companies that typically can't afford a full-time one. So they outsource to us, we charge them a flat fee, and we get to be that outside counsel for businesses. We answer phone calls, questions, review contracts, the typical thing that the big company would have in an in-house counsel.
Very good. And tell us a little bit about the size and types and range of your clients.
And most of our clients are service companies, and so they sell services or some kind of widget. And many of them just start out, let's say 1-2 years into the business, and realize they've gotten a little bit bigger than the internet forms they've used, the forms they've pirated off the internet. Or they have some issue that comes up and they think, you know what, maybe it's time to get an outside counsel to look at something. That relationship typically turns into the one I described to you. And we watch the business grow. And many of our companies now, almost 8 years into this, are multi-million-dollar companies that started out as mom-and-pop shops.
Right. Tell me a little bit about tell me what issue you're seeing right now that you think would be of import to the listener.
Well, there's one thing I don't think I've talked about in your show, and that is the bankruptcy principles. And the main thing that's happened, at least in the last month with my clients, is, say, one of these service companies who more or less are shells, money in, money out. They don't really have any assets. They now file bankruptcy. Well, in that bankruptcy, we've told the client, and many of your listeners probably already know, hey, there's an automatic stay. That creditor can no longer go and pursue that debtor for some debt, at least for the pendency of the bankruptcy. They get included in the bankruptcy. They get to discuss with the trustee what assets exist, and they're included amongst the secured and unsecured creditors. Many people know that little game. It's sort of unfortunate because it tends to burn the mom-and-pop shops who really need that money. They really can't float customers more than 60 days. The principle that's come up in this last month is pre-petition payments. So, again, same example with the mom-and-pop shop who can't really float a customer for 60 days, gets a notice somewhere down the road, a year down the road, from the trustee of this debtor's bankruptcy who says, hey, mom-and-pop shop, you got a payment, say, 45 days prior to this company filing bankruptcy. We want it back.
Oh, wow. Wow, I see that.
Clients take this big, deep breath, and they go, are you serious? This has been a year. Our books are closed. We've already spent that money. There's always some issue that we all can relate. And they call me and go, is that true? Do we really have to return this when we provided the service or built the widget or did whatever? Is that true? The simple answer
wow.
The simple answer
that's one of those things. I have a hard time not seeing that as potentially abusive. And so, how common is that?
Very common. Here's an example why. Say you're on the other side of it, and you're one of those creditors who didn't get paid. Say you have a $50,000 debt out there from this debtor, and in the pendency of the bankruptcy, you learn that there was another creditor who got, a $30,000 payment 45 days before the bankruptcy, and you didn't. Now how do you feel? So it works the other way, too, when that creditor then goes and petitions the trustee to say, wait a second, you need to undo this, trustee, and go get back that money to let all of us creditors who didn't get any money split it. So that money would go back into the pool and divvied up however the trustee determines is fair and reasonable depending on whether that creditor is secured or unsecured. So it does work both ways, but typically I get the phone call from a desperate client who says, how do I come up with, 30, 40, 50 grand just to give back? Now what?
Yeah, what do they do?
Well, here's what they do. The trustee is going to have to sue, which means filing an adversary proceeding in that bankruptcy. So it's a whole separate lawsuit in federal court. Many times you can say, I don't have any money, and you know what? You get a judgment against you, life goes on, you're judgment-proof. If, in fact, you're also a shell company, money in, money out. And then life goes on. But if you really do have some assets and you don't want to shut down the business because this could shut you down, you then file some defenses like the pre-petition payment was for other things. It was for new consideration. You put in there many other defenses, and you require the trustee to do their work. And the reason for that would be, even if you don't fully prevail, you try to get that case into mediation so that, say that $40,000 debt could become 5 or 10 or 15, just because, like, you don't want to pursue this because of the expense, the trustee doesn't either. They're trying to get as much money to appease the creditors to shut this case down.
Yeah, very interesting. Is there anything on the front end a business can do to kind of prevent or mitigate that kind of risk?
I get asked that question a lot too, and I guess the easy answer is going to have to be no. Sadly, it's going to require you to know the financial condition of your customers, and many of us just don't, only because we're worried about the financial condition of our own business.
Yeah.
So you kind of get bitten later on, and the sad thing is it's more or less a cost of doing business. And I'll say in 15 years of practice, it's only happened, every few times a month, or a year rather. But when it happens, it's pretty devastating, especially
huge,
to a new mom-and-pop shop company.
Got to wrap it up. Marc Krasney with the Krasney Law Firm, your website?
KrasneyLawFirm.com, Krasney lawfirm.com.
I'm Kevin Price. You've been listening to The Price of Business. More for you right after this.